Hello, it's Sandra Pike from Royal Page Atlantic, and today we have the lovely Dainelle McLean from DCL Law. Dainelle, thank you for joining me today.
Oh, thanks for having me.
So, I've had several clients over the past few years talk about probate, and I like to call it purgatory for the seller and for the family. I just like to, get you to explain what probate is, and then I'll ask you some questions from there on in, if that's okay.
Sure,
Okay.
sure.
So talk to me about when, I keep wanting to say purgatory. When does probate happen here in Halifax?
So, from a real estate point of view, you're going to have to probate an estate anytime that you don't have a joint tenancy. So, if you and I were on title together jointly, if I die, it's going to automatically go to you. If
Yeah.
it's just you on title and you die, then we have to probate your estate in order to move that title. So, what probate is it's a way to prove that either your will is the absolute last and final will, it's a valid will, or if there's no will, it's to prove that all of the proper heirs are listed and that they're going to get what they're entitled to get. So it's a process whereby you have that assurance that it's able to be sold. So probate is going to appoint either an executor if you've got an executor named in a will, or an administrator if there is no will, or if you've got a will that's not properly done, or it doesn't have an executor, or the executor has passed. It's going to appoint that person that can deal with the property.
So how long would the process be?
Well, I'm going to give you the lawyer answer, which is it depends. So it's not something that you can turn around in 24 hours. So, as I say a lot in my real estate law career, is we just need to slow down. So, when you know you've got a situation whereby you're going to need probate, you really need to stop and assess what you're dealing with. So, if you've got a will, it's likely going to be a slightly faster process than if you don't have a will. That's going to depend on who those heirs are if you don't have a will, because you do have to figure out that category of people, and you've got to figure out who's entitled to be an administrator of the estate. You've got some notices and everything that you have to serve. And frankly, it takes a little bit of time for probate court to process the file once you get all the information together that you need to get together. I would suggest something you can absolutely do by yourself, or you can hire a lawyer to do it. If you're under a tight timeline, I would suggest that having a lawyer is the way to go because they already know that process. That
Yeah.
said, in Halifax, anyway, a probate court's fabulous. They'll help you. They'll walk you through things. A lot of the forms are online, but it's not something that's going to happen overnight. It can take anywhere from a few weeks to a few months just to get it opened up.
And so it could take 6 months for a property to go through probate before you could even sell it, correct?
Yeah, so once you have the grant of probate or the grant of administration, then you have somebody that's legally appointed to deal with the property. Until you have that grant, there's really nobody that's even entitled to sign that purchase and sale agreement on behalf of the property, or even to hire you as a realtor in relation to that property. So I'll see this all the time whereby it hasn't been probated yet, and somebody's saying they're executor of so and so's estate is signing the paperwork. But until probate court says that they're the executor and there's a grant, they actually don't have the authority to contract on that property. So once you have the grant of probate or the grant of administration, then that person can legally contract on the property. So they can hire the realtor, they can enter into the purchase and sale agreement. This is where we get into the it depends. So, depending on the situation, because once they have that grant, they have to serve notice on the beneficiaries, either the people that are named in the will, or the people at law that should be entitled, or the people that would inherit if there isn't a will. So sometimes when we do that, people don't agree. So sometimes you can end up in disputes, you can end up with issues. So as an executor or as an administrator, you are liable for your actions while you're acting in that role. So depending on the situation, you may want to wait until you get to the point where you can wind the estate up before you're conveying the property. Now, a lot of times when we see this, it's, a spouse conveying the property of another spouse. They weren't both on title. The spouse is the only heir. That's nice. That's clean. Nobody's going to really dispute it because it's the spouse's property. A lot of times what happens with this is we'll sell the property, but the money either stays in trust or it goes into the estate account because there is a 6-month advertising period. So once you
Yes.
get that grant of probate, you have to advertise in something called the Royal Gazette, which is a newspaper that only lawyers read. So in that you say, hey, I'm the executor of such and such an estate. If there is any claims, you have 6 months to raise them. And if you don't, then too bad. It's so sad. Now, there are some mechanisms in there we can get past that. But generally speaking, you're going to put that out. And that's when you would get like an ambulance bill or, somebody saying that they loaned you money, that kind of stuff. So until you know what those claims potentially could be, you really don't want to start spitting money out of the estate. The other thing is our friends at CRA are going to require that there's a tax return done on that estate, and an executor or an administrator should have that clearance certificate at the back end saying that they don't owe CRA any money because that executor or administrator is liable to CRA if they spit money out of that estate to the beneficiaries without paying that first. So, it depends. Every situation is different, but at a minimum, you need that grant, and then you kind of decide what it is that an executor or an administrator that you're comfortable doing. If you're comfortable selling the property, keeping the money in trust, if you're comfortable taking it and distributing it, generally we don't recommend that unless you're the only heir anyway.
Just to back up a little bit so I understand. So even if the property is going through probate, I can sell and put the money in trust?
You could. Assuming again, and it's going to be situation specific, but you could absolutely, once you have that grant, they can contract depending on the terms of the will. The will may say that they can't do that. The will may say that you have to give 8 months till Johnny decides if he wants to buy the property. Like, it's really going to depend on every specific situation. If you've got a situation where you don't have a will and you just have some random heirs in there, and sometimes we don't even know those heirs well, because they're cousins or whatever it may be, you really want to be careful with that because you don't want people disputing what your actions are. A lot of times if you have a will, it says right in it, they have the power to sell, they have the power to contract, they have the power to do all these things. It's a little bit of a cleaner situation. Very fact specific, very situation specific on that. Like, really, you need to stop and you have to have a lawyer give somebody advice before they go down that path and they enter into a firm contract.
So speaking of a will, if I just write something up, is that good enough, or should I be in front of a lawyer, doing my will?
Again, that depends. So generally something is better than nothing. We do have very specific requirements for a will in Nova Scotia. So you have to have 2 independent witnesses generally. And you have to have an affidavit stating that from at least one of those witnesses, it's either notarized or witnessed by a lawyer or someone at probate court stating that they witnessed the will. So what we find sometimes is people try to draft their own wills and they create issues because it's not worded properly, so it kind of creates some circular circular issues, so you can't figure out who's supposed to be doing what and who's entitled to what. So a lawyer joke is always that we love will kits because we make a lot of money on them on the back end cleaning up the mess. Even if you do it yourself, I would suggest having a lawyer take a look at it to make sure that you haven't missed anything big. I've seen some really big mistakes made, after someone's passed and we get the homemade wills, and made very, very large errors that caused the estate a lot of money and caused everybody a lot of pain. If you've got minor children in there, so, like little kids, you really shouldn't be trying to draft your own will because you got to be careful with language in there for trusts. So you need to watch what you're doing on that kind of stuff. If you're doing something simple like everything to my neighbor Joe and nothing else, maybe, but again, then a lawyer would be asking the questions of, what are the questions we ask isn't just who are you including, we're asking who are you excluding, because that matters. Can somebody make a claim on this, right?
No, I think, that's a conversation I was having with my parents. Now mind you, I'm an only child, but like, you know, it's, the last thing that I want to go through is a long, lengthy process, because I'm already probably I'll already be in a state of mind where, you know, losing my parents and that grief. And the last thing I'm sure anybody wants is to go through that stress and just live the pain of, you know, your loved one not being there. So I think, you know, having a will with a lawyer is it's just something so simple to do. And I believe so important for people to do.
Yeah, and not even just having a will, but keeping a record of what you have.
Yes.
So I'll have clients that will come in and they're the executor of an estate, and sometimes there's even spouses, you know, and this is typical kind of in an older generation where you have one spouse that handled everything. So you have one spouse that did all of the banking and all of the loans and all of and then they pass. And the surviving spouse doesn't even know where the bank accounts are. And I've had that happen. And
Yeah.
I've had a son in my office once that was like, I had no idea where mom even banked. I dropped her off and the wallet was lost. It was, you know, in the manner that she died, lost, you know, everything was gone. And went to where he would drop the parent off and went into every individually bank to see if she had an account there because they weren't sure.
Yeah, that's important. Yeah,
So,
we
you
have that all
know,
written down in our safe.
and
Very
that's a
important.
really important tool for an executor or an administrator is to have that list of where things are, not even just account numbers, but just, you know, I bank at Royal Bank, my insurance is with these people, my medical is with this, I have a life insurance policy with this. My grandmother passed, we wrapped up her estate 2 years later, I realized she had a life insurance. This is my grandmother, I'm a lawyer. So you know, it's we don't you don't know what you don't know.
No, I agree. So thank you so much for taking the time once again today. Really appreciate your feedback and insights, you know, just on the market and, you know, other legal matters in real estate. So thank you.
Anytime, take care.